Hello friends, welcome to the channel Ka Kaydacha and a new video of a question and answer. The first question is related to Kul Kaida or a Tenancy Act. Now the question is, what exactly is a provision of a section 32G of a Tenancy Act? Now we must understand that Tenancy Act was enacted with a specific purpose to give back the ownership of a land to the person who is actually tilling it. Earlier, the tillers known as Kul were as good as the slaves of a saukars or the landlords. And the very intent of a Tenancy Act or a Kul Kaida is to give back the ownership of a land to tiller. Now, the specific provision of a section 32G is that of a fixing of a price of a tenanted land. Now, whenever a person is recorded as a secured tenant for any land, he has the right to purchase the said land, and the tribunal created under this specific act generally fixes the price to be paid by the tenant to the government, and once the price is paid, the land is given to the tenant on an ownership basis. Therefore, in nutshell, the section 32G speaks of fixing of a price and the various other provisions related to determination of a price of a tenanted land. The next question is, father gifted the ancestral property to brother. He mortgaged it for loan. Now can I get that back? Now first of all, we must understand that every ancestral property is not a owned property of a person whose name appears on the land revenue record. Now, since your father has gifted the ancestral property to your brother, now it seems that he is the only owner of that land, and by using that name on land revenue record, he has mortgaged the land for the loan. And now you want to have your land or share of land back. Now first of all, is it possible? Yes, if it is an ancestral land, since you all will have a separate undivided share in the land, you can very easily or positively have your share back. However, to get back your share, you will have to challenge the documents those are in contravention of your share. That is to say, the gift deed and the mortgage deed, if any. Now, when you challenge the gift deed and the mortgage deed, and if you succeed in the challenge, it is very much possible that you will get back whatever is your rightful share in that ancestral property. The next is where to register a sale deed. Now I would like to answer this question not only restricted to sale deed but for all the agreements and documents. Now whenever it comes to registration, a document is registered in a sub-registrar office within whose jurisdiction the property is situated. For example, a property is situated at a place. Now, to register an agreement, we must approach the registrar office within whose jurisdiction that land is situated. Normally, a registrar office is allocated or appointed at every taluka level. Moreover, in urban areas, considering the numerous agreements, single taluka may have more than one registration offices. Now, in case there are more than one registration offices, we have the choice to register the agreement in any of those offices. So, in a nutshell, you have to register any agreement related to property in a registration office within whose jurisdiction the property is situated. The next is how to calculate the government value or the reckoner value. Now first of all, let us understand in a transaction the two values are very important. The first is the actual price or the actual consideration, and the second is a government value or the reckoner value. Now why we have a reckoner value or the government value? The reason being the stamp duty. Whenever a property has been transacted for a price and a price of a price fixed by the government or the reckoner value differs from that price, then the stamp duty is levied on the amount whichever is the higher. Suppose there is a transaction of a property for 100 rupees and the government value or the reckoner value of that property is 80 rupees, then naturally the stamp duty will be levied on 100 rupees, that is a higher amount of an actual consideration. Now how to have your government value or the reckoner value? The simplest, safest and the best way is to take the relevant documents of the land or the property to the local registration office, and the staff there would easily calculate the reckoner value or the government value. If you require the value only for the reference, that would suffice. However, if you intend to have a certificate, then you can have a application in the standard format, and then they will issue a valuation certificate that can be used for all legal purposes. The next is what documents of structure are available and how to get it. Now when we talk of a structure, it cannot be constructed in an air. It has to be constructed on some land. So when we are talking of a structure, we start with the land, then the various permissions, then the sanctions, then the approved plans, and then the specific agreement related to a specific property. For example, first you have to take the Satbara or the property card, then you have to look into all the permissions, amended permissions, revisions, etc. Then you have to go for a sanction plan. Then suppose in that sanction plan you are concerned about specific flats, say flat number 2, 5, 10, whatsoever. Then now you have to look into the specific agreement related to that specific unit constructed thereon. So whenever we are talking of a structure or a constructed premises, we start with a land, then we go to sanctions and permissions, and then we end in the specific agreement related to the specific property. Now the next is father gave land to daughter. Does her married daughter and sons have the right? Now whenever a question of a right arises, it largely depends of a nature of a holding, that is the ancestral or a self-acquired. In this case, if the father has a property self-acquired and he has given the self-acquired property to his daughter, then till she is alive or if she executes a will, the rights of her heirs are on her wish or limited to the will executed. Whenever we say a property is a self-acquired property, then so long as the person or the owner is alive or he has executed a will, the rights of heirs are restricted to the will. No ancestral property or no ancestral rights can be attached to a self-acquired property. Now, irrespective of it's a son or daughter, they cannot claim anything in self-acquired property of their parent so long as they are alive. On their demise, their rights will be governed either by the succession, if there is no will, or if there is will, then by the will itself. On the other hand, if the property is an ancestral property, then irrespective of a transactions, the rights of every heir will be determined by the family tree and a degree of his holding in that family. So whenever we have to ascertain right in a property, the first and foremost question we have to look into is the nature of holding. If it is self-acquired or ancestral. The nature and extent of holding of legal heirs solely depends on whether a property is a self-acquired or the ancestral. The next question is my grandfather's name is removed without any document. Now what to do? Now since the grandfather's name has been removed without any document, it must have been removed by the mutation. Now to challenge that mutation, you need to approach the competent authority, that is a subdivisional officer, by challenging that mutation entry by way of filing an RTS appeal. Now, considering the dispute of a land revenue record, it is within the exclusive jurisdiction of a revenue department. The civil court doesn't have any right about the land revenue records. The civil court cannot do or cannot pass any order about the defect of land revenue records. So, when there is a defect or fraud in land revenue records, the only option to be exercised is to approach the competent revenue authority by way of an appeal. Now the next question is how to remove encumbrance of a tenant under the Tenancy Land Act. Now when a price is fixed, the encumbrance of equivalent amount is placed on that land. And now when the tenant pays that price or pays that nazrana to the government, naturally that encumbrance is then removed. The next question is, here I have executed the registrar isar receipt. Now the seller is not coming for sale deed. What can be done? Now first of all, isar receipt or isar pauti is not an agreement in itself, but it's just a receipt of an amount. Now since it is not an agreement, it cannot be legally enforced. However, I would request you to once again look into the matter whether the document registered is in nature of a receipt or in nature of an agreement, if there are any terms and conditions. If it is a receipt, I doubt if we can do anything. However, if it is an agreement and a well drafted agreement, and if there is a breach of any of the terms and conditions, we can very well drag the opponent to the court, and most probably you will get the appropriate legal relief from the appropriate legal authority. The next is, I am Muslim, my father sold ancestral land, can I get it back? Naturally, considering the ancestral property, every person of that family has an equivalent and undivided share. However, as far as Muslim personal law is concerned, I am not an expert to comment on that. So therefore, I don't know, as per Muslim personal law, which person or which heir is given how much of share. So if you can inquire about the Muslim personal law board and the share you are entitled to as per that personal law, then you can very well fight or initiate a legal proceeding to get your rightful share back. Today we have seen some questions and their answers. I hope you have liked the video. If you have any such personal questions or answers, questions or queries, you can ask those in comment section of our videos. Some selected questions and queries will be answered in our next question and answer video like this. Thank you for watching.